Hi, I'm Laurie Webb-Daniel from Atlanta. I'd like to say a few words about post-trial motions. Post-trial motions are an incredibly critical part of the trial proceedings, or I should say the proceedings in the trial court. However, the problem with them is that they come at the end of the trial when you're absolutely exhausted after having slugged it out with your opponent. So my advice is do yourself a favor. Enlist the help from someone else with some fresh eyes, a fresh perspective to take a look at your work product to make sure that you don't miss anything. An appellate practitioner is good, but someone you trust, a law partner who has a good perspective also can come in and give you some insight to make sure that you don't miss anything. For example, if you lost the trial, this is a time, an opportunity for you to turn things around in the trial court. Obviously, it would be much better to go into an appeal as an appellee rather than the appellant. This is an opportunity for you to turn things around. Even if you think that the trial judge is going to deny your post-trial motions, however, they're very useful for cleaning up your record. Although you should really make your points for a JNOV before the end of the trial, sometimes you can use post-trial motions to elaborate on your previous points, or as long as your points are somewhat connected to your previous points, you can elaborate and bring in some new concepts, some new ideas. So they're very useful for making sure you have a good foundation for your appeal. Also, there's some issues that you cannot address before the trial is over, such as the excessiveness of a damage award and certain constitutional issues, for example, punitive damages that may be unconstitutional. Now, if you won your trial, you also want to take the post-trial motions very seriously, because you certainly do not want to lose your case at the post-trial stage. And even if you're very comfortable with your position, it's important to take your post-trial filings in the trial court seriously. For example, you would not want to waive any waiver arguments that you might have. If, for instance, the defendant failed to make a point before the trial was over in connection with the directed verdict motion, and then tries to make the point in its post-trial motion in connection with a JNOV, you must object to that in your own post-trial filing. Otherwise, many courts will hold that you have waived the waiver argument. So really, my bottom line advice on post-trial motions is, first of all, take them very seriously. Second of all, give yourself a break and ask someone to come in and look over your work product before you filed it to make sure that you haven't missed any important point.